now for those that are here at the Zoom meeting. Thank you. Cheryl.
Ooh. Are we there? Can you guys, did I lose you?
No, I can hear you wonderfully.
We can hear you.
I can't see a thing. Oh, there we go. Go ahead, Scott. I'm going to let Scott go ahead first.
Okay.
Okay, can we do the PowerPoint as well?
Sure thing, whenever you're ready. Let me make you co-host so you can have that available.
I can share it.
Or if you give it to Jason, Jason is much more technically savvy than I am.
Works great.
I got it, Adrian.
Okay. Terrific. Well, first, let me just say to everyone, thank you very much for having us here today. For those of you who don't know us, I'm Scott Ford. That's Cheryl Wallach. Also with us today is Annalisa Swan. We're all attorneys and we all work at the same firm representing injured workers. Our firm's a little bit unique in that we, as far as I know, are the only workers' compensation firm, perhaps the only law firm that is organized by a labor union. Teamsters 986 represents all of the staff members in our law office. Would you like to introduce yourself, Annalisa?
Hi, good afternoon. My name is Annalisa Swan. I'm an applicant's attorney with Ford&Wallach. I'm a longtime member of the CLU Los Angeles chapter. I've been the secretary, was the secretary for about 4+ years. And I really enjoy what we do. I've been with the firm since March 8th, 2004. Thank you.
So with that said, let me tell you a little bit about ourselves. We do specialize in representing injured workers. I'm certified by the State Bar of California as a specialist in workers' compensation law. I've also been named a super lawyer by Los Angeles Magazine for the last 14 or 15 years in a row, which is a poll amongst lawyers themselves as to who the best in the profession are. I also sit on the board of directors of the California Applicants Attorneys Association, which is a group that advocates for injured workers up in Sacramento. I've also served as a judge pro tem, which means a temporary judge at the Workers' Compensation Appeals Board in Marina del Rey. Not so much that I'm here to give you my resume today, but just to let you know that this is all I do 24/7. I specialize in workers' compensation. I only represent injured workers. I don't represent employers. I believe in what I do. I teach at LA Trade Tech College. Because I teach at LA Trade Tech College, where I've been on the faculty there for 25 years, I'm also a member of the American Federation of Teachers. I also serve on the executive board of the AFT as well for Trade Tech College. With all of that, Cheryl's credentials are similar, if not better than mine. So I'll let you introduce yourself, Cheryl.
Good afternoon, everybody. I'm Cheryl Wallach, and I'm the better half of Ford&Wallach, as I like to say. No, and it's a pleasure being here. Besides basically the same resume as Scott, I am also a past secretary of CLU in the late 90s, early 2000s. And I am also on the board of directors of WorkSafe, which is a nonprofit up in Oakland that helps protect and represent underserved employees, just making sure that they have a safe work environment. And we're tied in with Cal OSHA as well. And go ahead, Scott.
Okay. You know, what we often say, Cheryl and I, is, she's the work comp geek and I'm the work comp nerd, or vice versa. So thanks for giving us an hour of your time today. We'll try and do our best to teach you a little bit about workers' comp, and more importantly, a little bit about workers' compensation and COVID-19 claims. So with that said, can we go to the first slide, please, Jason? So today we're going to talk a lot about COVID-19. And the reason we're going to talk about COVID-19 is because we want to make it clear to everybody that if you get COVID-19 through the work, you have the right to file a workers' compensation claim. Often we use this expression arising out of the employment in the course of the employment. That's kind of like code language for attorneys, meaning that it's a work-related claim. I go to court pretty often and the judge will say, hey, Scott, is this case AOEC? And what he's saying is this a work-related claim? So what I want to make it clear to everybody today is that if you get COVID-19, somehow through your work environment, you have a right to file a workers' compensation claim. As a matter of fact, early on in the pandemic, back in March of last year, the insurance commissioner of the state of California, Mr. Ricardo Lara, issued a proclamation. And in that proclamation, he made it clear that COVID-19 transmitted through the workplace was a valid workers' compensation claim. Not only was it a valid claim for regular employees, certainly a valid claim for undocumented employees, and also perhaps a valid claim for what some previously we called gig employees as well too. Can we go to the next slide, please? So first slide is everyone has a right to file a claim. The second slide is, well, does everyone need to file a claim? And the answer is no. Not every claim is worth pursuing. Not everybody needs to file a claim. We all know that when we have workers' compensation claims, that they take time, they take energy. You go to court appearances.
Is there a
you go to-
technical issue that I can help you with in advancing the slide?
Nope, I think we're good, Adriana. So anyways, you have not every claim is worth pursuing, because we all know and we hope that at least 85% of the people who get COVID are going to make full recoveries, or they never even knew they had it before. I say we hope it's 99 or 100%, but so far it seems that at least 85% of the people who get it are going to make very strong recoveries. And for those people who, a couple months after COVID are back to normal, they're exercising, they don't have any residual symptoms, they may or may not choose to file a workers' compensation claim because it may not be worth their energy to go through all of this. This is a no-fault system. It's a system where we only compensate people based upon their permanent impairment at the end of the case. So when you make 100% recovery, there isn't necessarily a monetary recovery for people, and people have to decide whether or not that's going to be worth their time. We in our office would love to be a resource for everybody. We're happy to talk to people. A lot of people call us up and ask us, should I file a claim? Should I not file a claim? It's conversations that we have every single day, and we're happy to have them with people if they want to talk about it. Go to the next slide, please. So let's get back to this issue of arising out of the employment in the course of employment. We're going to do our best to sort of train you to be workers' comp attorneys today. And when you're a workers' comp attorney and you use the expression AOEC, everyone knows what you're talking about. It means, was this a work-related claim? Is this arising out of employment in the course of employment? There's a three-part test to file a workers' comp claim. Number one, you got to be a covered employee. Number two, you got to have an injury. And number three, it's got to arise out of employment in the course of employment. That's kind of workers' comp 101 for us. So let's talk about COVID-19 though. The flu, if you get that at work, it's not a work comp claim. You get a cold, you get that through work, it's not a work comp claim. But COVID-19 is different. And it's different because the World Health Organization labeled it a pandemic a long time ago. We also know it's different because no matter what we do to try and stop the spread of it, it's not necessarily possible, especially when you have people who are dealing with people in the public, especially when we're dealing with people who don't control who's in their environment.
Sorry.
Adrienne, is that you again? Did you want to say something? Okay, so how do we prove AOECOE? How do we prove that a work comp claim is valid for COVID-19? Do we have to bring, Dr. Anthony Fauci down to the courthouse and say, hey, look, judge, I've got the number one expert in the country here on COVID-19, and he's going to show you my blood work? No, it's actually really easy, and it's not that scientific, and it's not that technical or even specific. The standard to file a workers' comp claim is that you have to show that the work that you do gives you an increased risk as compared to the general public. So in other words, the kind of work that you're doing makes it more likely for you to get COVID-19 than somebody maybe who's sitting at home. And if you can show that, you can show that you're entitled to a workers' compensation claim and potentially workers' compensation benefits by showing an increased risk. It's my personal opinion that anybody who works with the public, anyone who works with strangers, absolutely unequivocally qualifies for filing a workers' compensation claim, because that type of work puts you at a greater risk to the public. The public may be sitting at home, telecommuting. If you're working with strangers, you don't have that luxury. Okay, go to the next slide, please. So under the law, again, the standard is we have to show an increased risk. But in addition to that, we have some laws that have come out this year that make it a little bit easier to qualify for workers for COVID-19 claims as well too. Our governor, Gavin Newsom, issued an executive order back on May 6th of 2020, indicating that anyone who got COVID-19 through the workplace between March 19th and July 5th, who worked outside of their house, was entitled to a legal rebuttable presumption that that COVID-19 was a workers' compensation claim. So let me repeat that again. The governor issued an executive order saying that anyone who worked outside of the house between March 19th and July 5th was entitled to a presumption under the law that that COVID-19 was a work-related claim, okay? So this gets a little bit complicated. It's an executive order from our governor, but it's only valid for the first 107 days of the pandemic. So people who caught COVID-19 for the first 107 days from March 19th to July 5th, who are working outside of their house, have a presumption in their favor when we go to court saying that they're entitled to workers' comp benefits. Can we go to the next slide, please? So what is a presumption? It's a great question. Well, if I go to court and everything is equal, how does the judge decide who wins? Well, sometimes we look at the weight of the evidence, but when there's a legal presumption, a judge automatically finds for one side. So in other words, if all of the evidence is equal and one side is presumptively correct, the judge makes the ruling in favor of that side. So let's back up a second. Remember what we just said. Anyone who was working outside of their house for the first 107 days of the pandemic, who got COVID-19, who comes to court and says, I got COVID-19 from work, and assuming all the evidence is equal, the judge is required to find in their favor. Now, I say that's assuming all the evidence is equal. It's called a rebuttable presumption. That means that the employer or the insurance company, the other side, has a right to show evidence that perhaps you didn't get it at work. Can we go to the next slide, please?
So as Scott was talking about, we have new legislation that was passed for COVID-19. And I really want to emphasize that even if any of these rules that we have don't apply to you, you still have the right to file a workers' compensation claim if you're working outside of the house and you contract COVID-19 due to work. Again, all you have to show is that you had an increased risk compared to the general public. So we have three new rules that we're going to be talking about. Scott mentioned Executive Order N6220. We also have SB 1159, which is Senate Bill 1159 signed on September 17th. And that's was brought in by Senator Jerry Hill. And then we also have Assembly Bill 685, which is by Assembly Member Eloise Gomez Reyes. And that's sort of the tracking device that sort of keeps employers honest. And we're going to go into detail about each new rule. But again, these rules have to do with rebuttable presumptions. And even again, if you're not part of this rebuttable presumption, if you don't fit into any of these categories, and you show that you contracted the virus at work or believe you contracted the virus at work, you just show the increased risk compared to the general public. And now we have the AOE COE. Can we go to the next slide? So Scott already talked about N6220, but we have California Senate Bill 1159. Again, it's a rebuttable presumption. We have three new labor codes. What is a labor code? A labor code is basically our rules that we follow when we go to court. We can't just say, oh, we believe this. We have to apply the law, which is the labor code, into our facts to show that we have an injury that arose out of the employment and during the course of employment. So Senator Jerry Hill's state Senate bill is three new labor codes: 3212.86, 3212.87, and 3212.88. And the next few slides are going to go into detail regarding the three labor codes. So Labor Code section 3212.86 is our first rule. And basically what it does is it put Governor Gavin Newsom's executive order into our rule book now. So now it's a law. Before it was a law, people were arguing maybe it's not constitutional what the governor's doing or something like that. But now that it's in our playbook, our rule book, it is now a law. So this labor code applies for people who contract the virus from March 19th, 2020 through July 5th, 2020, only for these 107 days. So for this short period of time. What you have to do to get the rebuttable presumption is, again, you have to have contracted the virus during that period of time. You have to test positive or diagnosed with COVID-19 within 14 days after you've worked. You cannot be working at home and saying you contracted the virus due to work. You have to have a confirmation of the COVID-19 by a test within 30 days of diagnosis. And then the employer has 30 days to investigate the claim. This is really important because under the general rule for every other type of workers' compensation case, the employer has 90 days to investigate the claim to determine if it's going to accept it or deny it. So they have time to investigate to see, did this really happen out of work, happen due to work? This speeds up the process and only gives the employer 30 days to investigate the claim. And again, the reason for that is because the virus is so deadly, so they wanted to speed up the system. Can we go to the next slide? The next labor code is 3212.87. This basically extends what Governor Gavin Newsom did under N6220 or under 3212.86. It extends it for some frontline workers and extends it from July 6th onward. This was signed by the governor on September 17, 2020. And again, it gives a rebuttable presumption to frontline workers if you contract the virus after N6220 expires, basically. So from July 6th onward, you have a rebuttable presumption. Again, if you test positive within 14 days of last working, not working at home, and it speeds up the investigation period and from 90 days to 30 days for the employer/insurance company to investigate the claim for them to determine if they're going to accept or deny the case. Can we go to the next slide? So finally, we have 3212.88. That's for everybody else, basically. It provides a rebuttable presumption for other employees, but the employer has to have 5 or more employees. If you have less than 5, this doesn't apply to you. You get a rebuttable presumption. Again, it's really important to focus on. This only applies to whether or not you have the rebuttable presumption. And again, as we said, even if you don't have the rebuttable presumption, what is it we have to show? We have to show the increased risk compared to the general public. So you have to have 5 or more employees. The injured worker has to test positive with COVID-19 within 14 days after working after July 6th. There has to be an outbreak in the workplace. And what does an outbreak mean? So if there's 100 or less employees, 4 employees at the workplace have to have been diagnosed with the virus. And if there's more than 100, 4% of the employees have to be diagnosed with the virus. And the employer, instead of having the regular 90 days to investigate the case, has 45 days to investigate the case. So remember, if you're a frontline worker and you get the virus after July 5th, the employer has only 30 days to investigate the claim. If there's an outbreak and you qualify under 3212.88, the employer has 45 days to investigate the claim, which again is faster than the 90 days that a typical claim has. Can we go to the next slide? AB 685, like I said, is by Eloise Gomez Reyes, and it's really a tracking device for the employer. Remember, we talked about 3212.88 regarding if there's an outbreak. Many people should be saying, well, how do I prove there's an outbreak? Well, now you have your sword or your weapon to show the employer that they have to, by law, by AB 685, keep track of people who are diagnosed with COVID-19. They don't have to give away names or privacy or anything like that, but they have to have employee numbers and when they were diagnosed with the virus. This is effective January 1st, 2021. And again, it's a tracking device for COVID-19. It requires the employer to keep track of anybody who contracts the virus, and it has to advise all employees and, really important, the union when somebody is diagnosed with the virus. They also have to notify the public health agency within 48 hours, and they have to provide a protocol of how they're going to disinfect and control the exposure and keep the employees safe. So again, this is a really powerful tool in order to apply 3212.88, Labor Code Section 3212.88, in regards to seeing if there's an outbreak. But it also helps to tie in, even if you don't have the rebuttable presumption, showing that the worker that is saying they got it at work can show all these other people that got it at work. Can we go to the next slide? So most people, when they contract the virus, need to make sure that they do a few things. The most important thing to do is to document some more, and document some more. The reason why we tell you this now is because we may not be going to court in front of a judge to say that we have AOE, COE for months, if not a year later after you've contracted the virus. So documentation, written documentation, is the best thing that we can have. So 3 people are really important to document. The first one is, of course, is the injured worker. Once they are aware that they've tested positive for the virus, they should go back and put in a calendar what events they attended and what did they do outside of the house or outside of work to show, again, that with reasonable medical probability, they had an increased risk compared to the general public, and they contracted the virus at work. They could talk about if they have information about other people that they were exposed to while they were at work, other coworkers who were exposed. Were they the first person in their house that contracted the virus versus their spouse or children brought the virus home, and actually they were the ones that gave it to the employee? What was their custom and practice during this time of washing their hands, changing their face mask? Did they change it every day, or did they reuse the same face mask over and over again? Did they just use a little sanitizer and walk away, or did they really wash their hands for singing happy birthday for the 20 seconds that they're supposed to do under hot water with soap? All of these things will help prove, again, that the injured worker contracted the virus at work. You as union leaders or unions are also important for documentation. They can sort of be the hub, especially under Labor Code Section 3212.88, to show that there's an outbreak. Anything that they can do to keep track of how many people have contracted the virus at the workplace will be helpful. They can sort of be the center of gathering all the information. The doctor is also the third person that needs to document. The reason for this is because you're compensated based upon symptoms and permanent impairment that you have due to those symptoms. So if you start having foggy brain, if you start having hair loss, if you start having respiratory problems, if you start having orthopedic problems, if you start having deconditioning, high blood pressure, anything that can be related to the virus, it needs to be put in the medical report. They also can help show that it arose out of the employment and during the course of employment. If I have a report that the doctor says injured worker thinks they contracted the virus from a coworker on this date, and I go to court 6 months later and I show that to the judge, that's going to be extremely powerful and persuasive. You have to remember the employer on any type of case, but especially COVID-19 types of cases, they're going to show, look, it's not AOE, COE. We didn't have an increased risk. We had a safe work environment. We have all these different procedures in place to make sure that nobody is within 6 feet of somebody else. We have rules that everybody has to wipe down their work area. We have where nobody is allowed to eat in the cafeteria area. They're going to show anything that they can do that the injured worker did not contract the virus at work, but they're going to show you got it from a family member, that you went to an event, you went to a restaurant, any other thing that they can prove to show, again, that it didn't arise out of the employment and during the course of employment. Can we go to the next slide?
Let me unmute. So there are 5 benefits of the workers' compensation system. So the question becomes, okay, I'm trying to argue that my COVID-19 is work-related, that I have a workers' compensation claim. If I prove the AOE-COE, it arose out of my employment in the course of my employment, what am I entitled to? Well, everyone who's injured, whether it be COVID-19 or whether it be a back injury or carpal tunnel claim, is entitled to the same 5 benefits of the workers' compensation system. The first of those benefits is medical treatment. Absolutely unequivocally the most important benefit that we deal with. And it's the most important benefit when you deal with COVID-19 claims. You're entitled to medical treatment to cure or relieve the effects of your injury for your entire life. So past, present, and future. Very important benefit, and one of the reasons why many people are filing COVID-19 claims, because we don't know what's going to happen in the future. And if we're worried about what will happen to a long hauler or potentially somebody who has dormant symptoms now that may come back, we want to see if we can get them that lifetime medical award. But with that said, like everything else we say, we want to do this the right way. And the right way is that if you get COVID-19 and you have a significant problem, you need to get medical treatment from any source you have. And so I want to remind everybody that there's a statute of limitations to file a workers' compensation claim, and that statute's 1 year, generally 1 year. It can be longer if you don't know that the injury is work-related. So in other words, you didn't know you got the COVID-19 from work. But with a year to file the claim, we know that in some of these really acute cases that people are in bad shape quickly. We know that some people, unfortunately, within 30 to 60 days can pass away from this. So when we file a workers' compensation claim, as Cheryl talked about before, the employer is entitled to 90 days to investigate a claim before it makes a decision if they want to accept or reject responsibility. In some of the circumstances, we may be able to get that as low as 30 days, but in most cases, it still remains 90 days. And in that 90-day period, while you're waiting around to decide whether or not your employer is going to agree that you had COVID-19, and you're waiting around to see if your employer is going to provide you that medical treatment, your condition can become catastrophic. So again, we want to help everyone file a workers' compensation claim. We want you to understand the first benefit of workers' comp is medical treatment, but we want you to understand that when it comes down to filing the claim or getting the medical treatment, get the medical treatment from any source you can, and then we'll file the claim when you are ready, able, and willing to participate. Can we go to the next slide, please? So again, we said there are 5 benefits of workers' comp. Medical treatment was the most important. We had to give it a slide by itself. But the other 4 are the remaining benefits of workers' comp. So let's talk about what those are. So let's start with temporary disability. If you're injured on the job, you're unable to work because of your injuries, you're entitled to a wage loss replacement. So in other words, you're entitled to get paid while you're unable to work. In California, you're entitled to 2/3 of your average weekly wages, up to a maximum amount in 2021 of approximately $1,350 a week. So if you are Donald Trump and you claim you make $1 million a week, you don't get $667,000, you get $1,350, that's the cap. If you are someone who makes $15 an hour, which is $600 a week, you don't get a raise, you don't get $1,350 on your temporary total disability, you get 2/3 of that $600 or $400. That benefit can last for up to 104 weeks. 104 weeks is the cap. Some people don't get a day of it. Some people get the entire 2 years. It depends on the severity of the injury. The third benefit of workers' compensation is the one that people probably talk the most about, and that's called permanent disability. And it's a better way of, or just common way to, it's money. You're entitled to be compensated for the extent of the injuries that you had. In California, the state legislature puts out a rating schedule where they indicate how much people are entitled to based on disability ratings between 1% and 99%. 1% entitles you to $870, payable over 3 weeks at the rate of $290 per week. 99% entitles you to $260,252.50, also payable at $290 per week. So let me let you in a little secret here, and that's nobody gets rich filing a workers' compensation claim. It's a great system. If we can get you medical treatment, get you paid while you're off work, get you something for your permanent disability along with the future medical award, but it's obviously never worth giving up a good job for. And that gets us to the fourth benefit of workers' comp, which is job retraining. You're entitled to a job retraining voucher. It's called a supplemental job displacement voucher that's worth up to $6,000 to be used towards some type of vocational school. Most of us who are in this organized environment, we have good jobs, we have good benefits. It's hard to replace those. So the voucher is something that we're often not looking for our clients. Obviously, when they need it, we want them to get it. But our goal in our office is that everyone who comes through our doors, we'd like to keep them at work. We want to do our best to keep them at work. If you qualify for the job retraining voucher, the state of California also has something called the Return to Work Fund. They'll make a $5,000 payment to anyone who receives a voucher because they were unable to go back to their prior job. And then there's the fifth benefit of workers' comp. The fifth benefit is a death benefit. And when I teach this class at Trade Tech, I always say to people, what do you get if you die in the job? And everyone says, he has an answer. And I always say, you get nothing because you're dead. But if you do pass away from either on the job, an industrial accident, or you pass away from COVID, or you pass away because of a complications of treatment or something, if your death is somehow related to your employment, the people who depended upon you for support while you were alive can file an application for death benefits. When I say the people who depended on you for your support, it means they're not like heirs in a will. I can't say, I leave all my money to my third cousin, Johnny, who was always nice to me. No, a dependent is someone like a child or a spouse or a parent, someone who you actually supported or had some support. Now, if they file an application for death benefits and they are fully dependent on you, one dependent in California can receive up to $250,000 payable at the temporary total disability rate, which remember maxed out at about $1,350 a week. If you have 3 dependents, the maximum benefit is $290,000. Again, not $290 each, but $290 to be split amongst the 3 dependents. So if you were to pass away and you left a wife and 2 children, then they would be able to file a claim for death benefits for $290,000 payable at the temporary total disability rate. If you have 4 kids or 4,000 kids, it makes no difference. It caps out at 3. Unfortunately, we've seen a lot of death claims because of COVID, people who've died because they got COVID-19. This is the benefit that their families are entitled to. Again, it's a lot better than not having anything, but the workers' compensation system is not a system that overcompensates people. That's it. Those are the 5 benefits. People often ask me, what about this? What about that? No, in workers' compensation, it's a limited liability system. It's a no-fault system. It's based upon the great compromise between employers and employees in 1913. And these are the 5 benefits of the system. And that's it. Next slide, please.
So I want to take a moment to talk about psychiatric injuries. They deserve its own slide because when it's related to COVID-19, we're finding that these are truly legitimate types of claims. We have people who suffer psychiatric injuries. You know how we talked about if you have brain fog, or if you have hair loss, or if you have lung problems, those kinds of things, you may be entitled to benefits if you contract the virus at work for those sorts of symptoms and those sorts of permanent disability. You also can be entitled to the 5 benefits for psychiatric injuries due to contracting the virus at work. We have people who are afraid they're going to get the virus because they're working at a place where there is an increased risk. We have people who've gotten the virus and they're afraid they're not going to get better. We have people who have gotten the virus, got better, but are afraid they're going to get it again. We have people, unfortunately, in our office, we have a few cases like this. It's not just one, but we have quite a few where people who've contracted the virus from work, came home, they did okay, but gave the virus to a spouse and the spouse passed away. So in essence, I hate to say it, but they've basically killed their spouse because they contracted the virus at work. These are very valid and legitimate types of psychiatric injuries that people deserve treatment, temporary disability, permanent disability, the voucher, any benefit that could apply for this type of injury. And again, these are very legitimate types of claims, and we just believe it deserves its own slide to bring this up to you guys. Can we go to the next slide?
So let's talk for a few minutes about claims that are not COVID-19 claims, because we still are representing people with all kinds of workers' compensation claims, not just COVID. And we get a lot of questions every day. And the questions range from, what if I'm injured at home to what if I'm furloughed now and I didn't file a claim while I was working? Well, the easy answer is that none of that's going to be a problem. If you're working at home and you have an injury, you're entitled to file workers' compensation benefits. There's basically three things we look at when we determine whether or not a claim is work-related. And that's one, does the employer have knowledge of what you're doing? Two, does the employer have control of what you're doing? And three, is there a benefit to the employer in what you're doing? So if you're working at home, if you were working at your work site and they sent you home to telecommute, and now you telecommute all day long and you are developing carpal tunnel, maybe because you didn't have the same ergonomic station at work, or maybe for another reason. Well, you still qualify for workers' compensation benefits. You don't have to be at the employer's premises to do that. Now, that's true for someone who has symptoms before they left and they continued. And that's true for someone who just has symptoms that started after they left the work. So if you are working at home and you have an injury, you have a right to file a workers' compensation claim. I have a case where a lady was in her early 70s. They sent her home because of her obvious risks. They sent her home as an investigator with 8 or 10 boxes of materials. They had those boxes delivered to her house. One morning when she was in her living room, she was walking to get something. She tripped over one of those boxes. She had an injury. That's a work-related injury. It doesn't matter that it was in her home. A lot of things that we talk about sometimes in injuries are what we call cumulative injuries. Two types of injuries that we all deal with, Annalisa and Cheryl and I. One's called a specific injury. Specific injury, for example, I'm climbing a ladder and I fall off the ladder. That's a specific injury. The second type of claim that we often deal with is called a cumulative injury or a cumulative trauma. Now, cumulative trauma, the best example I can give you of that is a carpal tunnel claim. It happens gradually, not over days or weeks, but sometimes months or even years. And many of the cumulative trauma claims that we deal with occur outside of the employer premises. Sometimes they occur outside of the normal work shift of 9 to 5, but they're injuries that occur over time. And when you've gone home to continue working and you've continued with that injurious exposure, you're certainly entitled to file a workers' compensation claim, again, even though you're not physically at the work site. Go to the next slide, please.
So if you remember, Scott mentioned that workers' compensation is a no-fault system. It doesn't matter if my employer leaves a note that says, watch out for this cord, do not trip on it. And I'm looking down and I just don't pay attention and I trip on it. Doesn't matter if I'm driving from one place to another for work and I'm negligent and I rear end somebody, but I get injured. Doesn't matter if the employer is negligent and didn't put the sign in saying, watch out for this cord. It's a no-fault system. You cannot sue your employer in civil court, and you can't get those big damages like you could in civil court. It was the part of the Great Compromise where we are entitled to file the workers' compensation case. There is an exception, though, when the employer is not taking your health and safety seriously, and it's something called a serious and willful misconduct of the employer. It's under California Labor Code Section 4553. This is a special claim that we can file in the workers' compensation court if you are injured or are exposed to the virus and get the virus, or have a type of injury where the employer is something akin to criminal negligence. It's where, again, an OSHA violation, or when it's related to COVID, when they're just not really giving a you-know-what to your safety and they're not providing a safe work environment. This is the additional claim that we can file against the employer. It's important, though, because for a regular workers' compensation case, we have generally 1 year to file, but we can extend that timeline if you don't know it's work-related or you don't know of your rights, something like that. But for a serious and willful misconduct, it's a strict 1 year statute of limitations. That means it's a strict 1 year timeline to file this additional claim in the workers' compensation arena, or else it's forever barred. So again, it has to be filed when the employer is not taking your safety into consideration and they're basically being belligerent or they're being unconcerned about your safety. If you do win a serious and willful misconduct claim, and it's up to the judge to determine this, the employer, not the insurance company for the employer, but the employer on its own has to pay the damages. They're hard to prove, and we don't know what a judge is going to do with these types of claims. But again, if we don't file them, the time limit will lapse and then it's too late to file it. But if we do win this claim, every dollar that the insurance company pays on those benefits that we talked about before that Scott mentioned, every dollar that the insurance company pays out, the employer themselves has to pay 50 cents to the injured worker directly. So it's a 50% penalty. It's almost akin to punitive damages. It's to punish the employer when they don't take your safety into consideration. Again, we don't know what judges are going to do, but we believe it's important to consider on a fact-by-fact basis as to whether or not this is something that should be filed in the workers' compensation arena. Can we go to the next slide?
So as you can see, all of our staff are wearing masks. It's kind of crazy to believe that this was taken over a year ago. Our offices are also deemed essential services workers by our Teamster Local 986, and we have not closed our shop. We have continued to operate, continued to take care of injured workers. We've spread out the staff over 2 floors, the 2nd and 3rd floor at the building, and opened up 2 shifts. So we have an early shift and an afternoon shift just to practice social distancing. We're also cleaning the workstations on a regular basis and the common areas on a regular basis, and some are working from home. We want to be a resource. We want to help your locals, the members of CLU. As Scott mentioned, and I just recently mentioned, all of our staff, we are a proud union shop represented by Teamsters Local 986, and Scott and Cheryl, also American Federation of Teachers Local 1521. We are taking lots of COVID cases, unfortunately, and like I mentioned earlier, we want to be a resource to the labor community. If you want to take this back to your locals and are interested in us presenting, please reach out to me. I'm very involved in the labor movement. I'm the secretary for LACLA, which is Labor Council for Latin American Advancement, and I'm out there quite a bit. We want to get each and every one of you a textbook. This is the textbook that Scott and Cheryl use for their LA Trade Tech class. If you email me at jswanson@ford&wallach.com, or you can send me a text to my cell, which is the 213-810-0365, with an address to mail you a book, I'd be happy to do that. If you have any, if you have a case, that you want to talk about, and we want to obviously respect your confidentiality in this Zoom, but call the office at the 213-380-3140. My extension is 2209. I'd be happy to schedule and facilitate a consultation with Scott or Cheryl. I've actually attended quite a few of the CLU Christmas dinners and looking forward with Cheryl and Adriana and Annalisa. Scott, we got to pull you out there to one of these times. But looking forward to hopefully seeing some of you at this year's Christmas dinner.
Was it Christmas dinner at Tay's, Jason?
It was.
Yeah,
Yeah, they just shutting that down, unfortunately.
they did. Well, we do
Yeah.
have some questions from other avenues, so let me know when you're ready for those. Lots of positives here, and thank you so much for the updates. A lot of things I learned today, especially when it was in terms of the rights that you have when you do get exposed or injured. A few things in the chat for those that are on the phone. If you don't see the chat, that's okay. We're going to save it for you. And you can, let me repeat, JSWANSON at Ford, FORDWALLACH.com. The recording has been saved. Please know that this isn't legal advice. We're just sharing information for you, for your benefit. Please contact their offices should you have further questions beyond what's been spoken about here. So one of the things that came up, Cheryl and Scott, was in terms of dependence, because we have now cohabitation, and would that be considered a dependent? And also for wives and husbands of same-sex marriages, and that came from our YouTube channel. What are your thoughts on that?
You want to go, Scott? Or, hi.
Sure. Well, I think when we look at a death benefit, we're looking at that issue of dependency. If I'm married to somebody who's independently wealthy and I pass away because of an industrial injury, even though that person is my spouse, they may not be entitled to death benefits because they didn't depend on me for that support. Some instances they might be. But again, when you're talking about, sometimes we talk about putative spouses, sometimes we talk about, living arrangements that people have. I think whenever you have someone who relies on another person for support, you have a good argument to make a death claim. I had a case years ago. My client was a mother, came to see me. The son was delivering pizzas for a large pizza company. He was killed in a motor vehicle accident. The large pizza company came to the table and said, hey, we agree that it's a work-related death, that he died while delivering pizzas, but since he was the child, there's no death benefit because no one depended on him. And, we did a little research and we had talked to the family, and it turned out that the parents had recently divorced and that the son had gone back to work to help the family, and that there was a younger sister, and the son had said to the younger sister, now that dad's gone, I'm going to take care of you. So I went to court with the idea that, hey, the younger sister is a minor and she was dependent upon the 16-year-old, and she's entitled to the full death benefit. And that was a case they agreed to settle, and they agreed to settle it for pretty close near the true value. So again, I tell you that story because I think what we want to look at is the issue of who depends on who when we talk about the death benefits.
Absolutely. I think that the same thing that whether you're same-sex marriage or if you're a grandchild, or if you have to go into the facts of how the person is dependent financially on the person who passed away due to the virus. Are there
I
any?
scrolled through the chat. I didn't see any other questions, but if anyone has a question, please feel free to raise your hand or just start speaking. Don't be shy.
And we often understand that questions can be sensitive and personal, and that's the reason why we're happy to take questions outside of this forum too.
Absolutely. A lot of times we talk to people and they just want to be able to sleep at night knowing they're doing the right thing, whether it is filing a claim or not filing the claim. And I think that's really important. And again, we're happy to be a resource. We talk to so many people every day saying, you're doing okay, or this isn't something that you should be doing, or that you're on the right track. So just keep that in mind.
Thank you so much for that reply. Yeah, I think sometimes it has to do with your condition. Certainly it has to do with the individual in the case by case basis. Hard to make extrapolations, but thank you for the question. A question was emailed to me in advance of the meeting, somebody who wasn't able to attend, and they said, is there any other resources or town halls they could make today? Are you able to make a special appearance for a particular union if that request comes through, which we can forward it along for you?
Go ahead, Jason.
Absolutely. Feel free to have them reach out to me, and you have my email address and my cell, and I'd be happy to schedule that.
And would that also include anybody within the state? Because I know this originally came out of Los Angeles and now it's at the state level.
Sure. The law that Scott and Cheryl are talking is only for California.
Okay, that's great.
Yeah, and we're happy to do this. We do presentations all the time, and I do a lot of trainings for different unions where we do statewide training as well too. The laws apply the same all the way from San Diego to Eureka, and this is we want to be part of the labor community. We want to be a resource. So if somebody needs some help, we're going to be there.
Perfect. We'll take a question from the gallery. Rosie Manning, please just hit the unmute button and ask your question to the panelists.
Okay, a great presentation. I appreciate it. I do remember seeing you all at the Christmas dinner. I do miss those, but I had a question. As I'm a federal employee and I was looking at all the California labor laws about safety, even though I'm a federal employee or even for the others and we're union members, shouldn't we be covered under those California labor laws as well? I mean,
Well,
like the safety.
Unfortunately, no.
I
There's
thought so.
a separate system for, are you a letter carrier or?
No, I work for the Los Angeles Air Force. I'm Department of Defense.
Okay, there's a
Yes.
federal workers' compensation system. There's a railroad employee system. There's a Longshoremen's Act. Every state in the union has its own workers' compensation system. To qualify for the benefits we talked about today, you have to be what's called a covered employee, covered under the California system. But with that said, so many of these issues are universal. All of the different types of programs have the same benefits, some type of medical treatment, some type of compensation while you're not working, and some kind of compensation when your injuries recover. And the concepts are very similar, but they have procedural differences.
We have a question from our Facebook audience, and they're asking, does that apply to the AFL-CIO unions? I think
Does what apply?
the benefits for disability. I think that depends on the
And anyone working in the state of California who is injured in the state of California. So you can either be a California employee or you can be someone even out of state who gets injured while in California.
Or you can be a California employee going out of state. I have a case, that person passed away. He worked in California and had to travel to Florida for a presentation and contracted the virus and passed away. And he was injured in Florida by contracting the virus, but we still have California jurisdiction, meaning we can file the case in California.
Yeah, so I would recommend for that person who asked that question, please follow up with the offices to determine what rights you do have. Thank you for the question. So we're going to ask for further questions from the audience here in person with us on the Zoom. Thank you for being here. Facebook, there's a little bit of a time delay, about 30 seconds, but I appreciate you putting in those positive comments there. And also for our other social media platforms, if you need a PDF file or something emailed to me, just go ahead and get in touch, or just reply to that email that you were sent from the notification about this meeting today. Okay, it looks like we've reached our time. Is there any other comments or any other suggestions that anybody would like to hear?
I just want to say thank you, and it's so good to see some of these friendly faces that I know and love, and can't wait to give you all hugs, hopefully this December.
Yeah, I agree. Really missing the in-person stuff. I miss the potlucks, but certainly the company is what makes it all worthwhile. All right. Well,
Thank you again. Nice to see everybody. Thank you.
Thank you so much. Everybody have a good, happy Saturday.
Nice to see everyone.
Thank you.
Happy
Take care,
Pride,
everyone.
by the way.